at the University of Michigan to help break this all down for us. So this was the one that a lot of people were watching, Professor. What did the court decide?
Including Roe v. Wade, that the court has overruled a 50-year-old precedent that had such significant impact on our society.
So, the conclusion was that this was a violation of the 14th Amendment. Does this come down to the interpretation of the 14th Amendment? What is the purpose of it? Is it that we are to be a colorblind nation, or is it that it was meant to right the wrongs of the past? Can you sort of flesh that out for us?
Sure. Well, that's the fundamental disagreement at the core of this issue. As we know, the Supreme Court recently has been saying we should pay more attention to the historical understandings of particular constitutional provisions. And it's interesting because it was clear that the historical understanding of the Equal Protection Clause, when it was passed right after slavery, was not to prohibit Congress from giving a helping hand to racial minorities. And in fact, Congress did that in a number of different ways back in the 1860s. So historically, it was kind of understood that the point of the Equal Protection Clause was to stop discrimination against racial minorities, not necessarily to stop government from helping them. Over the years, however, the Supreme Court has been increasingly adopting a more so-called colorblind rule that basically says institutions shouldn't be able to take race into account except in emergency situations, no matter who they are disadvantaging or benefiting. And that doesn't necessarily accord with the original understanding of the amendment. So,
kind of the question moving forward is, what does this mean beyond an Ivy League school or beyond universities? The idea of affirmative action, the reason it was even put in place initially was about diversifying the workplaces of government contractors, right? Now it's become like the central argument when it comes to education. Could this decision have an impact on beyond education?
Sure. Well, in two senses. In terms of its effects itself, Justice O'Connor, when a conservative justice, of course, when she last defended affirmative action, made clear that race-conscious admissions wasn't just about diversifying universities, but it led to diversifying the leadership of our country, diversifying
ruling on affirmative action, officially ending the practice in college admissions processes. Colleges and universities will no longer be permitted to take race into account when reviewing the college applications. Now, this is a reversal of the 2003 decision, which ruled that higher education institutions must consider race in students' admissions to promote diversity. The two cases brought before the Supreme Court by the Students for Fair Admissions argued that the decades-long practice was considered a disadvantage specifically to white and Asian American applicants. Harvard and the University of North Carolina, representing both private and public universities, say affirmative action should be upheld as their policies help ensure a diverse student body. Chief Washington correspondent, that's Major Garrett, is just outside the Supreme Court now, where we've just gotten the news. Major, all indications seem to indicate they were going to rule this way. Good morning to you. What are you hearing?
Good morning, Gail. Let me read directly from the opinion just released by the Supreme Court, authored by Chief Justice John Roberts. This is the most important paragraph in that very lengthy ruling. Quote, Harvard's and UNC's, meaning University of North Carolina's, admissions programs violate the Equal Protection Clause of the 14th Amendment. This opinion goes on to say, in part, eliminating racial discrimination means eliminating all of it. Essentially what the court has ruled, 6-3 in the University of North Carolina case, 6-2 in the Harvard case, because Justice Ketanji Brown Jackson recused herself because of her ties to Harvard, but 6-2, 6-3, the court has said that these admission policies, which do not include set-asides or numerical quotas, but they do consider race among many other considerations in the admissions process, is impermissible because the value of diversity, the court has argued, isn't enough to justify the harms done to other students, equally or possibly better qualified, applying to those institutions. This will have wide-ranging effects across American higher education. Many colleges across the country have been bracing for this opinion, trying to figure out how in the admissions process going forward they can create a diverse campus and collection of students in their student body, which is not only of value to incoming students, but many of their parents, without considering race. Well, the Supreme Court has now said you cannot consider using race in any means whatsoever in evaluating someone's admissions to a college or university in America. Gail?
All right, Major, thank you very much. Joining us now is CBS News legal contributor, that's Jessica Levinson. Jessica, what exactly does this mean for how schools will admit students now?
So exactly as Major indicated, it means that you cannot explicitly use race as a factor in admissions. So we already know that colleges and universities have planned ways to essentially try to still get diverse student bodies while not explicitly using race. So we might see colleges and universities put more weight, for instance, on where did you grow up? Do your parents have graduate degrees? What zip code did you grow up in? But colleges and universities throughout the country, this applies to all private and public universities and colleges, cannot explicitly use race when they're making a decision about who to admit.
Now, we heard them say that they believe that it violated the 14th Amendment's Equal Protection Clause. Can you just sort of break it down exactly what that means, that it violated it how?
So the 14th Amendment and the Equal Protection Clause says that everybody is entitled to equal protection under the law. And we know since the drafting of the 14th Amendment, that is meant to prevent invidious racial discrimination. And the question for the court really was, can taking race into account comply with the command from the 14th Amendment that we don't discriminate on the basis of race? What does equality really mean? And today the court said, Chief Justice John Roberts, in language that absolutely echoes other lines we've heard, the way to end racial discrimination is to stop taking race into account, essentially. This is very different from the view that the liberal justices have and Justice Jackson had. And she has a lengthy dissent explaining why equal protection allows the government, allows private colleges to say, we will take race into account in order to try and get to a place of equality.
And we heard Major say that the judge, Ketanji Brown Jackson, recused herself from the Harvard case because of her ties there. So when you look at it, when you look at the big picture, who benefits and who loses here?
Well, it depends on your perspective, but affirmative action programs were implemented. Actually, the legal reason was not to try and basically right the wrongs of our society. It was not meant to try to help people who had faced systemic discrimination. The point was to help all of us by creating more racially diverse student bodies. And I think a lot of people don't realize that about affirmative action programs. It was supposed to, again, benefit white students, Hispanic students, Asian American students, Black students. So if that's your perspective, then that help is no longer there. Now, for other people, they feel affirmative action programs have hurt Caucasian applicants, have hurt Asian American applicants, and that those applicants will be helped by the ending of affirmative action. We know from prior experiences in states like California that ending affirmative action tends to dramatically decrease the number of Black and Hispanic students in certain colleges and universities.
Yeah, I think, Jessica, you set it up perfectly. Depends on your point of view, because some people will be cheering this decision. Other people will be heartbroken by the news today. Let's bring in senior White House and political correspondent Ed O'Keefe. Ed, have you heard any reaction from the White House yet? I know this is just breaking now.
It is, Gail. We have been told to anticipate some kind of a reaction, but that the White House, its lawyers, and the president would want to read through the ruling first before really weighing in. He's got some time before he heads to some events in New York around midday where we might hear from him either on paper or in person. One thing to consider, though, when it comes to the issue of affirmative action more broadly. We recently did some polling on this, Gail, and it found that 53% of Americans believe that affirmative action broadly should be continued. About 47% said it should not. But on the question of race-based college admissions, look at this, just 30% think colleges should be allowed to consider race in college admissions. 70% think they should not. So it's not that the court is necessarily taking its cues from public opinion. It says it never does that. But it does show here that the ruling today reflects broad public opinion. And that is something that, obviously will be considered in the political space. But the Biden administration had argued that in the case of Harvard's admissions process, they didn't believe it was in violation of the 14th Amendment, that the policy should be allowed to stand, and that the court should allow the university to continue doing so. Obviously, they've run counter to that today, and will await a formal response from the president and his administration as to what exactly it believes. One other thing to call out here, in the ruling itself towards the bottom of the Chief Justice's opinion, he writes in part, quote, "Nothing prohibits universities from considering an applicant's discussion of how race affected the applicant's life, so long as that discussion is concretely tied to a quality of character or unique ability that the particular applicant can contribute to the university." We had anticipated there might be something like this that would say you can talk about it in your college essay, or it can be taken as part of a broad spectrum of reasons why you should be admitted. But the idea that a university is going to look explicitly at one's race alongside other factors is what the court today is saying is not allowed.
That sentence you just read is very interesting inclusion in this ruling today. You know, when you look at the big picture, how do you think this will impact the number or percentage of minorities who get accepted into universities? When you look at it on its face, you think, how will it not? How can this possibly not affect black and brown students here?
Yeah, look, there is some evidence that in recent years, as college admissions processes regarding race changed, there was a lower number of minority applicants accepted. Perhaps that is inevitable. And so that's obviously where a lot of proponents of what UNC and Harvard were doing are going to be concerned, that this could adversely affect the admission of black, Latino, Asian American students. But the other thing to remember here is back in 2003, then Justice Sandra Day O'Connor had warned that given the way society was changing and given the contours of affirmative action, she believed that at some point in the next 25 years, this ability for colleges to consider race so explicitly was going to get struck down. Now, almost 20 years later, it appears that has happened.
Thank you very much, Ed. Chief Washington correspondent Major Garrett, we're going to go back to him outside the U.S. Supreme Court. I wonder if we could follow up on what Ed was just saying. Yes. Major, I read recently between 6 or 7 students who had decided 6 or 7 states, rather, who had eliminated accepting students based on race, that there had been a significant increase in the acceptance of black and brown students.
Right. Let's go over the specifics on this, Gail, because this was argued before the Supreme Court. It was part of the briefs the courts considered. 8 states in the United States, and I'll list them off to you: California, Florida, Michigan, Nebraska, Arizona, New Hampshire, Oklahoma, and Idaho have banned using race as a factor in college admissions. California was the first. It did that by referendum. What has been California's lived experience since then? And this was briefed to the court. And the UC system, University of California system, its most selective schools, it saw a 50% drop almost immediately in admissions for black and Latino students. And the University of California system has tried to figure out a way to increase those numbers after taking race out of the consideration process. It has been unable to find a formula, a holistic formula, a non-formulaic formula. That's some of the terminology presented to the court to raise those numbers. So it had an immediate effect, and it has not rebounded since. And that is something that was briefed to the court, that there are real-world examples where if you take race out of the equation in any way, shape, or form, it is very hard to reach these goals of diversity that colleges, either private or public, have set for themselves. And as I mentioned earlier, and this has become a part of the conversation, it's going to be an ongoing part of the conversation, students coming to college want a more diverse campus body to go into. Their parents oftentimes prize that. How do you get there? What are the methodologies? That's going to be something colleges now are going to have to work out. And the experience in California is instructive. And those who represent and speak on behalf of African American and Latino students say it gets ever more harder once you take race out of the consideration process entirely. Well, that may be the result for those states in the country, unlike the 8 that have already banned it, that haven't done so now, because they're going to be reconciling those different difficulties and the challenges presented by creating a diverse student body on college campuses without taking, at any shape or form, race into consideration. Gail?
Major, thank you very much. It'll be interesting to see how going forward universities will make an effort to remain diverse. This is such a very important question that really affects all of us. Thank you. Once again, breaking news. The Supreme Court ends affirmative action in college admissions. Our coverage will continue on CBS News Streaming, your local news, and of course tonight on the CBS Evening News with Norah O'Donnell. This has been a CBS News Special Report. I'm Gayle King, here in New York.
All right, if you're just joining us, we are following breaking news this morning. The Supreme Court has just issued a major ruling on affirmative action. In a 6-3 decision, the justices ruled that the consideration of race in college admissions is unconstitutional. Let's bring in Evan Kamenecker. He's a former dean and former constitutional law professor at the University of Michigan. Let's also, are we bringing in Ed? Not yet. All right, let's talk to Evan first. All right, so Evan, let me ask you. If you're just following along with the special report, even before the special report, we were having a discussion about this. So help me understand something. If a university chooses to, for example, admit students that are legacies, in other words, they have parents or both parents who went to that university and also donate to that university. I'm specifically thinking about Harvard University, which some reports suggest 43% of applicants to Harvard admissions are white legacy students. 75% of those, according to the reports, would not have been admitted if their parents were not wealthy or donors or alumni to the university.
Applicants or they get in?
Sorry?
You said applicants. You mean applicants or the people that actually get in?
43% of Harvard admissions. People who get in. 43% of Harvard admissions are white legacy students. 75% of those would have been rejected if their parents were not wealthy or alumni to Harvard University. Could someone bring a case before the Supreme Court and say that is unconstitutional?
No. And the reason is because the statutes or the Constitution don't speak to discrimination on grounds like that. The Constitution speaks to discrimination with respect to race, with respect to sex, color, religion, national origin. But it would basically say that institutions could take into account legacy or money or things like that, as long as they have a rational basis for doing so. Now, that doesn't mean it's a good idea. And increasingly, universities, particularly private universities, have either reduced or stopped the practice of taking legacy into account. And to some extent, it is because they think that it has had a negative impact on racial diversity. But that doesn't mean it is nonsensical to do. It's nice for a university to have people who feel comfortable there, who feel excited to be there. And I suspect that some universities at least, will continue to choose to do so.
Can we talk a little bit about the dissent? The counter argument. I know that Justice Sotomayor, when she was listening to the arguments, she was questioning whether or not race. She was talking about the fact that race, in fact, does have an impact on your options if you grow up in this country. Other countries do, but we're talking about this country. That, in fact, African-American kids often end up in schools where there are fewer resources, where perhaps some of the teachers aren't trained as much. And to ignore that is detrimental and is dishonest in a way. Can we talk about what the dissent sort of played out, or what the dissent had to say?
Sure. Well, a couple things. I actually am quite intimately aware of the conditions in the Detroit public city schools, for example. Recently was involved in a lawsuit there that showed that the schools were essentially schools in name only. You had buildings that were falling apart, no air conditioning, no heating that worked, vermin that had to be scurried out or cleaned up after in the morning. As you say, shortage of teachers, shortage of accredited teachers, no homework that could be given to the students because they don't have enough textbooks to go around, and they had no access to laptops, so students do whatever work they can do in school, and there's no homework that can be done. Now, obviously, when you have lots of urban areas in our country, that tend to be minority dominant, that tend to have schools that are less well preparing them less well for higher education. It's not a surprise that they don't have the same opportunity to show their accomplishments, to do well on test scores, to wow their students with great essays, to do all the kinds of things that normally you have to do to present yourself well on in a college admissions application. But I'll say something more generally. One of the things that the Supreme Court majority focuses on is the negative impacts that it claims come from affirmative action, basically talking about the idea that for every minority student who gets in, or in your earlier question, for every legacy student, I guess, who gets in, somebody's not admitted. And I think it's important to understand that many, many more people feel aggrieved by affirmative action programs than actually are. So there may be a university that, for example, because of affirmative action, let's say 500 additional students get in who might not have otherwise, but 30,000 applicants who were denied might all feel that they were left out because of affirmative action. I talk to my students about driving around a crowded parking lot, and you keep going and going, and all the spots are taken except one that's reserved for service vehicles. And you think, dude, if that were not reserved, I'd be parked and I'd be shopping by now. But there's 100 cars circling, and all 100 drivers think they're the ones who are being disadvantaged because the one spot is reserved. In reality, only one of you are. And that may also be.
So I was going to say, that reminds me of the previous case that came up, and you probably have a better memory than me, but it was a young woman that was at the center of it, I think probably funded by the same group or a similar group. But at the end of the day, her claim that she was detrimentally impacted by affirmative action was rejected because she really didn't have the grades.
Yeah, and that's something that we see, and it'll be interesting to see. I don't cover education, but I know, for example, that the state of California has done away with affirmative action in the California university school system. They've had that in place since 1996, or they have taken it away, done away with it since 1996. It would be interesting to see what the results have been in the UC system. Professor, just stand by for a moment, because I want to bring in our senior White House and political correspondent, Ed O'Keefe, who is joining us from the White House. So, Ed, sort of broadly speaking here, this latest decision by the Supreme Court, with its conservative tilt, is again indicative of this sort of upending of decades of sort of established jurisprudence that's sort of redefining, I think, in 2023, in the last couple of years, our American life on a series of contentious issues like, for example, this one, and before it, Roe versus Wade.
Yeah. And as we mentioned a little while ago during the special report, I think it's important to remember that there were conservative justices 20 years ago foreseeing today. Sandra Day O'Connor at the time, writing in a similar case that dealt with affirmative action in colleges, saying there may come a day when this court ultimately determines, based on how society is going, and yes, because of the balance of the court, that this is no longer going to be allowed, and that is essentially what they're doing today. And again, it eliminates race as a factor alongside your scores and a handful of other things. But what the court says in its opinion is that it can be included amid a mix of other things, as if it were part of the interview process or an essay that's submitted that talks about some challenge you overcame in your life. And so it's not going to be eliminated entirely. It's just not going to be able to be weighted as equally as other things and as explicitly, because those that were pushing for this change have argued because of that process, there were Asian American students especially who they believe suffered and were denied admission to Harvard and the University of North Carolina and other institutions because they were using such a system. And again, it's important to point out, California, the place that most Americans would consider the bluest, the most liberal state of them all, rejected a referendum on this issue, a few years ago. And across that state, they said it wasn't necessarily necessary. And why wasn't it necessary? Well, there's evidence that among Hispanic, Asian, and black voters in that state, that they don't necessarily support it at all, the idea of race-based college admissions or the need for it, because increasingly those students are able to get into university based on the merits, based on their scores, based on the fact that their families have gotten to a point economically and socially where they can get into college. That's not to say writ large that's the case, but you're starting to see the change in part because those minority communities that programs like this were once intended to help are arguing increasingly, maybe not a majority of them, but enough of it is showing that the numbers are changing in such a way that perhaps, hey, maybe we don't need that anymore to help us because we can do it on the merits. Perhaps that's where the court is trying to steer the country. That's an abrupt change. It's not going to sit well with many Americans. But in our own polling, 53% of Americans support affirmative action broadly. 70% in a recent CBS News poll said they oppose the use of race-based college admissions. And, you know, so in essence, society or the country is to some extent with the court. Again, that's affirmative action overall. 53% believe it should be continued, 47% abolished. But on the specific question of race-based college admissions, there you go. And this is the partisan breakdown. 75% of Americans think it should be, or Democrats should be continued. Notably, only 47% of independents and 30% of Republicans think affirmative action should be continued. If we have the next slide on race-based college admissions, it's 70% don't think it should be allowed, 30% think it should be. You break that down, partisan differences exist but aren't overly dramatic. Republicans are widely opposed, and they're joined in that view by more than half of Democrats and by 3 out of 4 independents. Black Americans relatively more likely than white Americans to say colleges should be allowed to consider race, but still just split on it. College graduates are slightly likelier than people without college degrees to say so too. So, and then there's this important question. How much discrimination exists today? Notice the smaller numbers there as you go though. 48% of black people say there is a lot, 28% of Hispanics, quarter of Asians, 17% of white people. So, you know, thinking on this is changing and maybe changing in ways that people may not realize. Supreme Court doesn't take its cues from public opinion, but certainly, as you said, Vlad, this is a change in the ideological makeup of the court. That change, the 6-3 majority that conservatives enjoy, thanks to the Trump administration, certainly now being reflected in what has been for so long an explosive issue, race-based college admissions, how exactly affirmative action should be used to help advance people into higher education.
All right, Ed, stand by because we want to bring in CBS News Chief Washington correspondent Major Garrett for a little more analysis. Major is actually right in front of the Supreme Court. My question to you, Major, is does this stop at college admissions? Does this decision have implications beyond that in the workplace and perhaps beyond?
So based on my initial reading, and I want to qualify that very specifically, my initial reading of this decision, it is not a broad constitutional argument against affirmative action outside of the college admissions process. There have been some who have been fearful that the court might go beyond the question presented about college admissions based on my initial reading, and it's a very long opinion, so it will take some more time, and I will absolutely defer to constitutional law experts on this question, but I don't, in my initial reading, see this as a decision that has any impact beyond college admissions. That is not to suggest, however, that impacting college admissions is a minor issue in this country. It is not. Colleges grapple with this question all the time. And what the court essentially said, Anne-Marie, is if you use race, then you are using race as a marker to make a set of assumptions. And that set of assumptions benefits some and possibly harms others. And the way to solve that problem, the court majority said, is to eliminate it entirely. In the words of Chief Justice John Roberts, who wrote the decision, eliminating racial discrimination means eliminating all of it. In this sphere, Judge Roberts and the majority of the court are saying, colleges, you can figure this out. There are other ways to get to this, but if you are using race in your consideration process, you by definition are assigning a set of assumptions to one question, race. And those assumptions help some, hurt others, and the way to solve that problem is to take that out of the equation entirely. So what could colleges do? They could look at zip codes, they could look at household income, they could look at legacy status. Look, if colleges, particularly elite universities, public or private, stopped giving preference to those whose parents had attended previously or were big donors, that would open up a lot of admission slots. Will colleges be willing to do that? That would be an enormous leap. It might be an enormous leap in the direction of diversity, but it would be outside of the question of race. And what the court is saying is there are ways to figure this out if you so desire. But picking up on Ed's point from a moment ago, he mentioned California.
Right.
The University of California system, after, by referendum, California voters decided to end race as a consideration in admissions at their most selective University of California schools, they saw admissions of Black and Latino students drop by almost 50% overnight, virtually, within the first 2 years. And they have, through lots of means, tried to re-increase those numbers, get them back to where they were before race was taken out of the consideration process. They have not found a way to do that. So this is hard work, and it's the hard work now that colleges and universities across this country, with the result of this decision, are going to have to undertake.
I'm really glad that you brought that up, Major, because I know in California they have implemented all these sort of outreach kind of programs to go into communities and encourage more applicants. But it's, you know, kind of when you get to the point where you're applying for, you know, a place at a college, that's the final step on this journey. I mean, before that, it's about, you know, proper funding of schools. It's about proper access. It's about all these other things that this decision doesn't really kind of address.
And if I could, Anne-Marie, Sonia Sotomayor speaks to this in her dissent. At one point, she says this decision by the majority creates a superficial, these are her words, I quote, superficial rule of colorblindness in an endemically segregated society. Justice Sotomayor, who, like Justice Thomas herself, both of them were products, they have said themselves, of affirmative action in their college admissions process. And though both benefited from it, both have diametrically opposed positions on what it means and what it meant to them. For Justice Clarence Thomas, he believed arriving at Yale, stigmatized him because he thought many of his fellow law students thought he was only there because of his race, not because of his underlying qualifications and justifications academically to be at Yale. And that always, he said, burdened him in Yale and burdened him in his life after law school. Sonia Sotomayor looks at this more holistically and says, in our history, constitutionally and other laws, we have discriminated against people of color in this country, and that discrimination has kept them out of places like colleges and kept them out of places where you can generate generational wealth. And that history has to be taken into account when you think about the real-world lived experience in our past and how to redress that in the future. Diametrically different positions on the same issue for two justices who both benefited from affirmative action.
Yeah, though I don't know if Justice Thomas would agree with you on that conclusion that he benefited from affirmative action, but certainly Sotomayor has said, look, I had lower standardized scores than some of my other classmates, but I was capable.
Well, I mean, Justice Thomas said, yes, I got into Yale not because I wasn't qualified, but because they had a program by which they looked and sought after students of my kind. So he acknowledges that was in part how he got into Yale. But what he says, the stigma that he carried with it then and for the rest of his career burned in him this sense that this is a, on its face, unfair application because it creates a notion. It creates a set of assumptions, which is one of the things the court gets at here. And during oral arguments on these two cases, Justice Thomas kept asking, what's the definition of diversity? Can you give me a definition of what that word means? Because I know what the Constitution means. I know what equal protection means. I know what race consciousness means. You define diversity for me. And because he did not, and the majority of the court did not receive, to its satisfaction, a definition of diversity, what it means, what its value is, and why the state should go out of its way to allow it to continue, they said no. Because those are vague and imprecise, we were going to go with the precise language of the 14th Amendment. They understood, to their minds, application of the 14th Amendment and the Equal Protection Clause. You're going to say you're going to treat everyone equally by taking this out of that equation.
Yeah.
All right, major, robust discussion there. Stand by while we bring in CBS News congressional correspondent Nicole Killian, who's following this from Washington, D.C. for us. Nicole, what are you hearing?
Well, we are seeing a lot of reaction from both sides of the aisle. Most notably, you have a lot of Democrats that are decrying this position. Just a short time ago, Majority Leader Chuck Schumer released a statement saying that this is a giant roadblock and, of course, blasting the decision, saying that this will impact the admissions process for the next cycle of students. You also have Delaware Congresswoman Lisa Blunt Rochester, who's also running for a U.S. Senate, who said that she was at a loss for words, and that this decision by the Supreme Court to, in her words, gut affirmative action is wrong, plain and simple. On the flip side of the aisle, you have many Republicans who are praising this decision, calling it a welcome victory. For instance, you have Congresswoman Virginia Fox, who is on the House Committee for Education and Workforce, and she calls this, again, a welcome victory for countless students across the country. Other Republicans also weighing in, praising this decision, as well as some 2024 candidates, from former President Donald Trump to former Vice President Mike Pence, who has said there is no place for discrimination. You also have Vivek Ramaswamy, a Republican primary candidate, who says that he is glad that the Supreme Court has laid to rest the worst failed experiment in American history. So right now, a lot of this reaction seems to be right along party lines, and we know this will continue to be a politically charged debate as folks continue to react to this decision.
Indeed, Nicole, thank you so much. And we are going to continue to get reaction and analysis of this decision. We're also waiting for some more decisions coming down from the Supreme Court. Perhaps the next big one is the Supreme Court weighing in on President Biden's plan to forgive student loans. That is what he campaigned on. And so whether or not the court rules in his favor will be huge. We're going to take a break for now.